Welcome to our next panel titled How to Navigate U.S. Cyber Disclosure Rules and Regulations. I'm Eric Geller, Senior Reporter for Cybersecurity Dive. Our panel is going to help you understand and figure out how to deal with the web of current and upcoming cyber incident disclosure regulations that are out there. In 2023, the SEC finalized a rule requiring companies to disclose material incidents within 4 business days. In 2024, CISA proposed a rule that would require critical infrastructure organizations to report significant incidents within 72 hours. These 2 rules have inspired a lot of commentary and concern within the business community. And of course, those conversations are playing out against the backdrop of a growing patchwork of state and international regulations. So today we're going to talk about how the SEC rule is working in practice, what to expect from the final CIRCIA rule, our panelists' hopes for regulatory harmonization, and how the changing regulatory landscape is playing out in corporate boardrooms and C-suites. Before we get started, a reminder to put your questions for our panelists in the Q&A panel that's found to the right of the video window. We will try to address your questions as time allows, and we hope we have significant time at the end for some Q&A. My colleague, Cybersecurity Dive reporter David Jones, will be co-moderating this panel with me. And joining us on the panel are Matthew Eggers, Vice President of Cybersecurity Policy at the U.S. Chamber of Commerce, Matt Gorham, leader of the Cyber and Privacy Risk Innovation at PwC, Scott Algeier, Executive Director of the IT-ISAC, and Jason Manar, Chief Information Security Officer at Kaseya. Thank you all for being here. Let's just jump right in. Mr. Eggers, we've got to distinguish here between the 2 Matts or the 2 Matthews. Mr. Eggers, what can you tell us about how your members are finding the experience of complying with the SEC rule at this point in time?
Yeah. Eric, first off, thanks for having the chamber and me with you. I think there's a lot to cover here, but I would probably say, just to set the scene, when that rule was first proposed, I think there was a lot of consternation with it. The SEC rule, if you will, disclose material cyber incidents. I think in a lot of ways that concern or concerns, and there are many, remain. I would say anecdotally, and I say anecdotally only because the rule has only really been in force for about 2 years, right? The final rule came into existence in around August of 2023. I think that what you see is probably a mixture of consternation with the rule in terms of what it could entail for companies having to reveal material incidents probably too rapidly on the one hand. But I think there is a recognition that it is a real regulation. And maybe we might note, or I might just kind of reflect on the recent House appropriations provision that would deal with or withhold funding for an enforcement. But I think in a lot of ways, if I had to kind of bullet point or at least say how are companies looking at the SEC rule, there's probably a mixture of views. I think there's probably, to be fair, probably still some confusion about how to comply. Maybe to put a couple of bookends on this is, on the one hand, I think it was back in May of 2024, the SEC put out a statement saying, in effect, hey, you're reporting too much. And I think we knew that was likely going to happen. And then recently there was, I think, a message sent with the inclusion of a provision in the House Appropriations Bill that public monies could not be spent on enforcing that rule. So I think in a lot of ways, the concerns remain. There's some confusion, but companies are going to comply with the law and the regulation.
Jason, I wanted to ask, as someone who was, the CISO on the panel, given the SEC regulations, how are companies investing in cybersecurity now, and what kind of priority are you seeing from boards and C-suites in your company and other companies that you talk to in terms of how they prioritize cybersecurity?
Yeah, so let's first talk, if you will, on the material aspect. So a lot of talk is going on at the board level, along with the chief legal officer, as to what constitutes materiality. And depending upon who you ask, they're going to give you quite vastly different answers. However, if you look at the SEC law, it's what is material to investors. So, because that is so individual to me as an investor, what I may call material, you may not call material. And so, there is a lot of thought right now as to what that is. And what we're seeing, and I think what you saw even last year, is companies saying, well, we're not sure what that is. So, we're going to over report and make sure that we go above and beyond and ensure that anything that specifically touches our systems or could potentially be a cyber event or issue is going to be reported. So if it does in the future become material, we have reported it, we've complied by law, we're not going to get on the wrong side of the SEC. So what that means is we're really investing and we're having those hard conversations at the board level. We're having conversations with our counterparts across the C-suite to especially include legal as to basically what is going to trigger that materiality. And if you will, you have a playbook of what is material so that you can then quickly meet the timeline and deadline that the SEC has. And I do just want to say, Kaseya is not a publicly traded company yet. Maybe one day in the future. But these are conversations that whether you're public or private, you're having on an ongoing basis with your board and with your executive committee and your C-suite level leaders within the organization.
Matt, I just wanted to ask, when you're talking with your clients at PwC in terms of how they're dealing with these issues, you deal with a wide array of companies. How do you kind of counsel them on how to address these issues?
Yeah, I think the first, just to tag on what Matt said, a lot of apprehension initially and some misunderstanding about what the proposed rule at the time actually said. But once we took a look at it, I think you can break it into two pieces, and the conversations with the clients mirror those two sides. The first is around the 8K or the incident disclosure, and I'd say 3 buckets of activity around that. The first was around the actual detection and escalation of an incident, particularly as it relates to incidents that are related. And remember, the rule as it's set is consistent with what the 2013 and 2018 staff guidance is. So the material disclosure is the same as it was in terms of an actual disclosure. What's different is the timing of it and where you're going to disclose it. And so that piece of it is the first piece. The second is around the actual materiality determination. So both a quantitative and qualitative assessment. And the third is the actual disclosure itself. Once you've made a determination to disclose it, can you get it out the door on an 8K 105 within 4 days? And so on the incident disclosure side, I think companies over time, we acknowledged that initially there were a lot of material disclosures, so much so that as the SEC came out and said, don't do it on the 105 anymore, do it on the miscellaneous form. And then on the 10K side, I think a couple of things happened. One, where you're going to disclose your cybersecurity strategy and process and governance. I think initially there was very little concern about that, but then the SEC took some actions that caused companies to start to wrestle with two really good questions when you did the disclosure. The first is, have we undersold the risk and have we oversold our capability? That is, do what we know privately consistent with what we disclose publicly? And so oftentimes, particularly a CISO would engage in the very beginning of that disclosure process by articulating risk, articulating how the strategy works, but then through the process of drafting that disclosure, maybe they weren't as involved. And what that causes a lot of CISOs to want to be at the back end of that disclosure drafting process to answer that question. Yes, this disclosure is still consistent with what we know privately. so that that public disclosure is not diverging from what they know privately. And so those are the two big areas. I think largely the companies that I deal with have grown comfortable over time, that they're less concerned because they've kind of realized what they really need to do in terms of the incident disclosure. And really, when you look at the 10K, it's about form. I mean, you already had your risk factors, you already had your proxy, you did draft some net new, but it's largely consistent with the kind of information you disclosed in the past. It's just where you're disclosing that in a single form. And that goes to why the SEC promulgated the rule in the first place, to provide that timely, consistent, and comparable information to investors.
Hey,
Matt, you want to?
I was just going to ask a question, if I could, maybe just piggybacking on what Matt said, if I may, just to kind of stir things a little bit. Matt, when you're talking with your clients, when I think about that statement that came out in May of 2024, I more or less kind of took it to say there's reporting on 8K item 1.05 and 8.01. I don't do the filings and so forth clearly, but from a how standpoint, how to navigate these things, do you feel like your groups that you work with are understanding kind of which item to file on, or is that still kind of an open project? I tend to think it's the latter, but what do you think before we maybe move on?
I think we're starting to get to the point where companies are comfortable. I think, to your point, early on, we saw what amounted to over disclosure. That is, we're wrestling with whether this incident is material or not, and we're not sure, and oftentimes you aren't. The rule actually says you only have to disclose within 4 days once you've made that determination, but companies, being conservative in their approach, decided that they would release an incident that they knew not to be material, but they were doing it on the 105. And so I think it's that really, when the SEC came out and said, don't file a non-material incident on the material 105, but rather on the 801, I think that caused companies to kind of take a breath, and you saw less over disclosure. But the fact of the matter is that process, from the point you had an incident to the determination of materiality, the SEC didn't put a time frame on that, because there's obviously, you're waiting for inputs. It takes time to develop over time. And so I think as the rule has been out there a while, companies are getting more and more comfortable with that understanding. Again, there are still companies that struggle with that and are concerned about that, but more and more clients I deal with are very comfortable with that now that it's been out, and they've seen other disclosures. We've been through a full year of both 8Ks and 10Ks, and they're getting that sense of it.
Scott, you want to weigh in on how your members kind of deal with this?
Yeah, so I do. Yeah, thank you. So of course, thank you for the opportunity to participate. It's a really important discussion, and I think yes to everything that's been said. Right, there's some companies are getting it and understand. There was clearly some over reporting in the beginning, but a lot of the member companies I work with within my community, they're having the same conversations with their attorneys about how to determine what material is and what the proper way to disclose it is. But one of the questions that also comes up is the rule having the intended effect, right? So the rule was designed to give investors the awareness about material risks and on some of these cyber incidents. Has that worked, right? We're going through this reporting process. We're going through the costs of doing this. Is there a benefit to it? I don't know the answer to that. But as we have this conversation around all of these different regulatory mandates and the costs that we incur on the industry side to comply with them, we often don't really look at the benefits of them, right? Is the juice worth the squeeze, so to speak? And is the going through the process of disclosing, is this really beneficial to the investor community or not? I don't know that I know the answer to that, but it's a question worth asking, I think.
One of the things that I've certainly noticed with our clients are two unintended changes as a result. The first is around if you think about an incident disclosure and you imagine a triangle, and on the corners of the triangle, one side is the CISO CIO, one is the GC, and one is the CFO. It's about shrinking the size of that triangle and bringing those three together around materiality. So looking at materiality from a purely financial perspective, looking at it, the securities law definition of materiality is a legal judgment, so the legal view of that, and then the CISO CIO and the view of it. I think it's brought those three together with a common vocabulary, common understanding in ways that the rule probably wasn't intended to have that positive impact, but it has had a positive impact. And the other side of it I've seen is the relationship between boards and the CISO improving as a result of the rule. If you think about it from a CISO perspective, I'm sure Jason would agree, one of the most difficult things for many CISOs to do is translate technical cyber risk into business risk language for the board. And so I think boards, as a result of the rule, have engaged in that relationship building and meetings, so much so that the frequency of meetings with boards has increased. In fact, some boards are even having executive session with the CISOs, again, to build that relationship, to carry on those conversations. Again, probably not the intended impact of the rule, but certainly as a collateral impact.
A quick follow-up on that with Jason. You talk about the relationship between the CISO and other members of the C-suite, CIO, CEO, chief legal, etc. Do all these regulations change the dynamic between those members of the C-suite?
Yes and no. And the reason that I say no is because I think overarching programs have pushed towards a cyber risk or a cyber committee of some sorts that would have all those components in it. But to Matt's point, it has brought the topic front and center, right? When you see that there must be a AK filing, or you see that you're having a discussion around whether or not this is 801 requirement versus a 105, or a 105 all of a sudden becomes an 801 because of its materiality. You get into some really great discussions with the board of what that materiality looks like, not only to the company, not only to the customers, but obviously the investors. And when you get those kind of discussions, you understand and you have a better lens to view risk through. So it really helps project the CISO as well as risk, as well as compensating controls that need to be put in place within any organization to the forefront. So for my own company, we have an audit committee as well as a cyber risk committee that meet on a quarterly basis to discuss such topics.
All right, great. Eric, go ahead.
So let's talk a little bit about CIRCIA. I mentioned before that the CISA is in the process of revising the rule based on public feedback. Industry groups say it should be significantly scaled back, and we know that the Trump administration, as it's prioritizing deregulation in various areas, is pursuing a very business-friendly approach to some of these policies. I would love to hear from our panelists what your expectations are for how the final rule will look compared to the draft rule that was published in the previous administration. What do you expect the new team to keep in place? What do you expect them to pare back? Matt, we could maybe start with you.
Sure. As I look at the rule, I think obviously the rule as proposed took a broad view of what is critical infrastructure and took a broad view of what substantial would be. And so if you think about what the rule could be if it was finalized in its current form, I think though confidential disclosure as opposed to public disclosure, it would be one of the most significant disclosure regimes ever to be put in place as it relates to cyber. That said, I think because it's a private disclosure, it's confidential disclosure, it certainly would have the opportunity to provide government some insights that may have a net positive impact overall. I think in terms of what we actually expect to see, if we assume that we are likely to see somewhat scaled back the disclosure, you can't go more narrow than the statute that created that. And so that statute is pretty broad in terms of critical infrastructure and the substantial definitions and the ransomware payment definitions. And so while it may be scaled back, there's so much of it that's in statute that I'm not sure that it can come too small or much smaller than it is. I think it was about 477 pages, if I recall correctly. It is quite large. So maybe we'll see some scaling back of the actual rule itself. But I think the left and right limits of it, as a result of the statute, are likely to remain the same.
Matthew, I know that the Chamber has had certainly some of its own thoughts on the scope of the CIRCIA rule.
Sure.
I'm curious if you agree with what Matt said.
I think a couple of maybe points to draw from our discussion on the SEC cyber incident disclosure rule. That's generally kind of a private or non-public disclosure of the incident and the kind of the finer details. With CIRCIA, it's supposed to be confidential, protected, if you will. A big difference. I think CIRCIA is certainly not going anywhere, is one. Two, I think we need to see Mr. Plinky take office at CISA and probably put his stamp on whether or not they're going to take a look at the comments that groups like the Chamber filed a year ago, July 2. I think there's bipartisan agreement that the rule, and I understand why CISA at the time wrote it the way that they did. They get one crack at it. I think they wrote the definition in the proposed rule of a substantial or a covered cyber incident too broadly. I think in a lot of ways, the number of organizations that they had in mind, somewhere in the area of about 316,000, and maybe the number of incidents that any one covered critical infrastructure might have to report, is just too much. And I'm a big believer in pretty much taking things as we've got it. And based on member feedback, I think we want to get out of the gates with the rule where there's confidence that it works. It's working to achieve its intended purposes, to have entities report, perhaps more, but in a way that probably tactically and strategically advances cyber, not only for the company or the entity that's reporting, but peers in a sector, like, the entities that Scott works with day in and day out, and then overall sectors, the U.S. government and what have you. I think we just don't know what CISA has in mind, but I would say, if anything, if I had to send one message, it's take a look right away at the definition of a substantial or covered cyber incident and narrow that down a little bit, if not a lot, just to make sure that the rule, when it does become, it goes into effect, it actually kind of works. And there's more support for it than I think maybe the reg writers anticipated when they first wrote it.
Yeah, so I would like to add on to Matt's comments and agree with them. I think, even looking at the record, even some of the authors of the legislation were concerned about the depth and the scope of the regulations that were proposed. Certainly, the IT-ISAC submitted comments that had some concerns about the scale and the scope of the definitions. And it's not just a reporting issue, right? It's not just, it's not that companies don't want to go through and report. It's the time and cost involved of going through and reporting incidents that may not necessarily be national security incidents. Sure, maybe it's not. It would be nice for CISA to know. As I understand, CISA wants to know, but is it, is this a threshold of a national security incident that needs to be reported? I think the other, the corollary to that one, so 1A is the expense from industry worth it, right? Is it worth the cost of reporting the incident? What's CISA going to do with it? How are they going to turn it around? And then how are they going to turn around information, if at all, into back to industry in return. I think the second issue that we had in the when we submitted the comments a year ago or more was that the number of incidents that CISA would get as a result of the proposed rules would exceed CISA's ability to intake them, right? They would be overwhelmed with information. It would become noise. They wouldn't be able to return any type of analysis back to us. CISA has gotten smaller since then. So I think that concern remains, is if the scope remains the way it is, what will CISA have the ability to intake, handle, turn this into analysis that's useful back to industry, and it kind of covers some costs for industry for doing this, right? We're not asking for financial compensation for doing this, but if we're going to be going through the process of building the procedures and building the compliance regime to comply, there needs to be some value back to the critical infrastructure community, other than this information goes in a CISA, goes in the government and dies.
One of the things I'm hearing from our clients quite a bit is, because they use the broadest kind of PPD 21 definition of critical infrastructure, a number of clients wrestling with, some clients clearly are critical infrastructure and they know they are, but using those broad definitions, there are others that we're wrestling with. Are we actually a covered entity or not? And so, as I read the proposed rule, I think there were still a lot of questions on the part of clients we're dealing with, whether they would be included as a covered entity or not.
One thing I might know, I think it's important, maybe for entities that are watching, or hopefully others that aren't as plugged into the cyber policy discussion, is, from a standpoint of how to navigate rules and regs, I think it's important for companies, to the extent that they can, try to practice, if when possible, when doing tabletop exercises, kind of game out what it would look like to report a material cyber incident to the SEC, or to CISA under the pending CERCIA rule. There are, guides out there from the Internet Security Alliance and the National Association of Corporate Directors, 2023 guide, in fact, and I think it's going to be updated in 2026, can give people in companies, boards, directors, if you will, really some tips on how to do this well, or at least think it through with others, like Matt, Scott, Jason, whatever your role is. And then I'll maybe just finish by noting one of the things that we've got concerns about too, with the proliferation of rules and regs, is I think I'm concerned about CISO burnout. We want to make sure that when agencies are thinking about writing regs, they're doing so with the mindset that there's more that's going on than what that agency itself is promulgating, and that we need to have these rules and regs not only serve the purposes of which, let's say, the SEC is kind of shooting for, but serve a broader purpose of helping individual companies. And then obviously these disclosures, notifications, and reports helping the federal government trip up bad actors. I know that's a little bit more than you need, but I would say when you think about how and whether to report, there needs to be kind of a continuum between practice, if you will, and good outcomes that sometimes the company doesn't see.
Let me ask about
Matt. Real quick, if I might, Eric. Sorry, I just play devil's advocate just a little bit, and I'll hit on something that Matt had just pointed out, which is, while I don't claim to know the total intent of the bill, I can say that I had several discussions with CISA during the time that this was being enacted. And one of the things is just visibility. I think everyone on this call understands that there is only a very small fraction of reported cyber events that actually get captured. And while I agree with Scott or whoever made mention a moment ago that CISA has gotten smaller, and there's no way that they're going to be able to ingest the number of reports that they would have. Still having an idea of what that number looks like in the U.S. would be amazing at some point. And as far as what is material, not only within the SEC law that we were talking about, but also what is material to investigators and people within the government, far be it for us to say what may be meaningful to them from an IP that we would just think is maybe hitting our infrastructure, or some other TTP that we may pass along that didn't do material damage to us, but maybe very substantive to the government. So I just want to play a little devil's advocate there, because while this may add to our plate just a little bit as cybersecurity practitioners, I would also say, at the same time, in engaging with the federal government, at least in my situations, it is what we're able to report at the time, not we want a full forensic debrief with a 20-page report, XYZ.
Yeah.
So again, just playing a little devil's advocate, I'm happy for anybody to jump in and say something to the contrary, but just wanted to add that lens.
Jason, can I kind of riff on that for just a quick second, which is, I don't think we disagree. So I think when we think about CERC, it came about because many policymakers thought, perhaps rightly, perhaps not, that after we passed the Cybersecurity Information Sharing Act of 2015, which would kind of incentivize or protect voluntary information sharing, with the number of public incidents that we've seen over the years, I think policymakers felt that they just weren't getting the full picture. We worked very closely with Congress to try to get a good bill and law. The only thing I'll probably say, just to keep things brief, is I think it's important with regulations to kind of get out of the gates in a way that there's more of a cooperative spirit on reporting, less adversarial. Then you can grow a program over time if need be. But I always think it's important to kind of build confidence and keep building. And so kind of getting a mandatory reporting program right out of the gates, and it's hard, it's really hard, is important. I'll stop there. Thanks.
Jason, you kind of touched on some of the issues I wanted to ask in this next question. You and Matt have similar law enforcement backgrounds, so you have an idea when there is an incident or when there is a threat out there. You look for certain information from your partners in the private sector. So I'm wondering, how closely, when you were on that side of the aisle, did you work with private sector partners, and when something happens, what kind of information is actionable for you? What do you want to do with that information once you get it?
Yeah, well, I'll just quickly say that without our private sector partners, when we were with the FBI, we got very little done. Our private sector partners meant everything to us, and Matt hit the nail on the head when he said there has to be a collaborative effort. So the main thing that I always wanted to do in any kind of investigation was to make sure that I had tangible, tactical information that a company could use when they came to me on any kind of threat actor that I was investigating. And we were very fortunate in the FBI and out of the cyber division where we worked for, that we had those relationships where we were able to pass along that information, which often told various industries exactly how the actor would act. It would also tell them a lot of times how much they would negotiate if it was a ransomware. They would start talking about TTPs, IOCs, everything that the company may not have figured out quite yet, as well as various tactics that they utilize to help them figure out what was going to be targeted next within their environment. And quite frankly, when Matt talks about collaboration and cooperativeness, that's what I think should come from, CISA or any kind of government, organization. But Matt worked side me there. Interested in your comments, sir.
Yeah, I think when I think about it, I guess the first piece is, how often does the FBI get a phone call? And the short answer is because we don't have that national data breach legislation. We really don't know. But there was a case a couple of years ago where, as a result of the access the FBI had, they actually had the denominator. That is, they knew every single victim of this particular ransomware actor. And of that totality of victims, 20% of them contacted the FBI, and the FBI contacted the other 80%. So if that's indicative of what we see, only about 20% of companies are contacting law enforcement when they have a cyber incident. When I was in government, the two most often cited reasons why they didn't, as it relates to ransomware, was I wanted to preserve my option to pay the ransom. Nothing stops you from paying a ransom if you contacted the FBI. And I'll come back to that in a second. And the second was I didn't want 20 FBI agents in raid jackets showing up at the business and going hands on keyboard, neither of which would take place today. If I go back to the I'm considering paying a ransom question, if I was considering paying a ransom, I would want to talk to the FBI. And my first question would be, do you have a key and a decryptor, and can I have it? Because sometimes the answer to that question is yes. And when the answer is no, what can you tell me about this group? Do they provide a fast key, a slow key? Are they under OFAC sanctions? Can you give me, as Jason mentioned, IOCs or other TTPs that you have on this particular actor? Can you put me on my technical folks on the phone to the FBI case agent and computer scientists that do nothing but work this group all day long? And so there's a lot of value over the course of the last 5 to 6 years where it went from an environment, I think, where the FBI was viewed as showing up and trying to make a criminal case, and therefore maybe a drag on the organization that was trying to recover, to the FBI is often there solely in an assisting role, providing those things I just mentioned, and not really there to collect forensic evidence, because they may have all the forensic evidence they need on a particular group at that time. And so to me, I think the relationship between the private sector and public sector has shifted. We go back a decade, it was the private sector thinking that government had the secret sauce, and if you just gave it to us, we'd all be better. They wanted, timely, actionable, relevant intelligence at scale. And that scale is difficult. And so we worked through that over the years. We've gotten to the point where we are today, and I think we're in a much better position, and we're dependent on each other, because the private sector can't solve this problem alone. The government can't solve this problem alone. We really need to work together holistically to be able to address it.
Matt, if I could just jump in and just ask you about the law enforcement or the temporary disclosure delay related to the SEC rule, in terms of how, maybe, and whether to disclose. Do you think that temporary delay at the behest of the AG has been a kind of a catalyst on some levels for more comfortable reporting? My sense is that change in that rule was a pretty significant change and much appreciated in the context of a rule that a number of entities were very uncomfortable with. Your thoughts?
Yeah, I think, we actually haven't seen it in use. The one case that's out there wasn't a material incident, it was a non-material incident that was delayed. But I think, look, there will be cases where there's a public safety or national security concern to delay that reporting. But I do still think it's going to be a rare occasion when there's a public safety or national security impact from the disclosure. And so I think it's a good thing that it's there, but I still think it would be a rare case where it was actually utilized.
As we move towards the end of the session here, I would love each of our panelists to share a little bit of advice that they would have for CIOs and CISOs about navigating this regulatory landscape. I think folks watching might have a lot of questions about what to do. So Jason, maybe we could start with you. Any thoughts you want to leave folks with?
Yeah, I mean, at the end of the day, collaboration is key, whether it's with federal entities or whether it's with your own C-suite, and making sure that you talk about these things before they come to fruition. meaning before that you have to action them. Someone briefly brought up tabletop exercises and incorporating these kinds of disclosures into your tabletop exercises. That's exactly what we have done over the course of the last couple of years, and we found that that helps in a very meaningful way. So if I had to leave anybody with that, it would be incorporate disclosures into your tabletop exercises so that you can have those difficult conversations early on and not in the moment.
Scott, you want to jump in?
Yeah, so I agree with that, right? You need to have plans and processes and policies in place ahead of time, because if when an incident does occur, you really can't start from scratch. I think what I'm seeing a lot of companies talking about and doing internally is engaging outside legal counsel ahead of time. So to help them talk through what risks that they have, help them develop these policies and procedures, not just corporate counsels, but outside attorneys as well, who specialize in cybersecurity and risk management, helping them come up with the policies and procedures, the incident response plans, the frameworks, and then also helping them navigate the risk assessments. And there's some discussion as to whether this might provide some assistance during the breach response as well, right? Where you have an established legal relationship with an outside counsel that you can engage on with attorney-client privilege. And this isn't to shield yourself from any reporting requirements. Of course, you need to do reporting requirements, but it does provide a little. It can provide a little added protections for some of your internal deliberations.
Matthew, what do you think?
Yeah, I think I often will kind of end with a message of tough love, not only for policymakers and regulators in particular, but for businesses. I think for their own good, because we want them to be successful and thrive and compete. So on the one hand, I would say to agencies, particularly during notice and comment periods, and I know they'll say, well, we just can't talk to folks because that might bias one interest group over another. I think the fundamental flaw we have right now with policymaking is agency officials just don't communicate with industry. So whether we see a 130-page rulemaking or a 400-page rulemaking, companies just don't understand what they're trying to do, perhaps to companies or with them. So that's one. I would say be a better communicator. And I know that that's going to be an ongoing thing. And then two, I would usually say to companies, be caught going the extra mile for your own good. I see a lot of times companies, businesses tripped up by cyber incidents, and I think it does them very good to, let's say, be caught going the extra mile, because that's not only good for them in terms of expense, reputation, and what have you, but it's good for the sector in which they operate with our economy, our national security, and so forth. So I'll finish on those 2 points.
And Matt, 15 seconds. What do you think?
Yeah, I think Jason hit it on the head. It's about exercising and the collaboration that's involved in that, shrinking and refining decision-making process at the operational, executive, and board level. Anything you can do in that space will leave you better prepared during the time of an actual incident.
All right. Unfortunately, that is all the time we have. Thank you, Scott, Matthew, Matt, and Jason for your insights and information. And thanks to you in the audience for joining us. Please stay tuned for the next session provided by our sponsor, OpenText. And following that will be our final session of the afternoon, a panel moderated by my CIO Dive colleagues, Matt Algeier and Lindsay Wilkinson. Thanks again, everyone. Enjoy the rest of the event.